I am going to discuss the Muslim Women Protection of Rights on Marriage Act 2019. This law was enacted to prohibit the practice of triple talaq. According to section 3 of the act, talaq to be void and illegal. Any pronouncement of talaq by a Muslim husband upon his wife by words either spoken or written or in electronic form or any other manner whatsoever shall be void and illegal. As per this section, the proclamation of triple talaq is illegal. Talaq has various forms and only triple talaq, that is talaq-e-biddat and instantaneous talaqs are applicable under this section. Section 2c, that is definition of talaq, clearly stated that what are the talaqs comes under this act. Talaq means talaq-e-biddat or any other similar form of talaq having the effect of instantaneous and irrevocable divorce pronounced by a Muslim husband. Normally under Muslim law, there are various forms of talaq, that is talaq-e-sunnat, talaq-e-biddat. In talaq-e-sunnat is divided into two, that is talaq-hasan, talaq-ahasan. These two forms are revocable. However, the triple talaq or talaq-e-biddat is irrevocable. We can discuss the various forms of talaq in details, and also we are discussing about a decision of the Kerala High Court, and after discussing this decision we can understand more about the various forms of talaq. Here we are discussing a case came up before the High Court of Kerala arising from a complaint filed with the police. A case was registered by the police after receiving a complaint from a Muslim woman. The woman alleged that her husband had pronounced triple talaq against her. After registering the case, the police submitted a charge sheet before the court. The facts of the case are that the husband pronounced talaq. He submitted this case before the Honorable High Court, and his argument before this court is that he pronounced talaq-e-hasan, which is revocable talaq, which involves pronouncing talaq on 3 different dates. Specifically, he pronounced talaq on the following dates. The first talaq pronounced on 26/6/2022. The second talaq pronounced on 12/6/2022, and the third talaq is on 22/6/2022. Furthermore, he provided a 90-day period for revocation, which was explicitly stated in the notice. Though the version of the husband is that he pronounced talaq-hasan, the police registered a case against the husband stating that the talaq he pronounced was instantaneous, which is false under the Muslim Women Protection of Rights on Marriage Act 2019. We would like to discuss the various forms of talaq, particularly talaq-e-hasan. Paragraph 311 of Principles of Muhammad Law deals with the different modes of talaq. Among them, in talaq-sunnat, 2 types of subdivisions there. One is talaq-ahasan and another is talaq-hasan. Talaq-ahasan, this consists of a single pronouncement of divorce made during a tuhar. Tuhar means period between menstruations, followed by abstinence from sexual intercourse for the period of iddah. In this form, a single pronouncement is sufficient, and after the menstrual period is over, the talaq will take effect. However, before the period is completed, the husband can revoke the talaq either expressly or implicitly. For example, if the husband and wife have sexual intercourse, it is considered an implicit revocation of the talaq before the iddah completed. So the ingredients are only one pronouncement of talaq is in talaq-ahasan, followed by iddah. Before completing iddah, the talaq can be revoked by the husband. When the marriage has not been consummated, the talaq in the ahasan form may be pronounced even if the wife is in her menstruation. So if the marriage is not consummated, meaning the husband and wife have not had sexual intercourse after marriage, then in this case, talaq can be pronounced even during the wife's menstrual period. No tuhar is necessary if the marriage was not consummated. Another form of talaq is talaq-hasan. This consists of 3 pronouncements made during successive tuhars. No intercourse taking place during any of the 3 tuhars. So in this type of talaq, it consists of 3 pronouncements made at successive intervals. This means that after the first pronouncement is made during the first menstrual cycle, the second pronouncement is made during the second cycle, and the third pronouncement is made during the third cycle. Normally means in between Tuhar period. Normally in our practice, what we do is we send letters at these 3 successive monthly intervals with acknowledgement card. The intervals are based on lunar months. However, calculating these intervals can be challenging as the menstrual cycle varies from person to person. Therefore, we typically send letters one after the other at 1 month intervals. The first letter is sent in the first month, and the second letter is sent second month, and the third letter, which is in the final one, third month, thereby completing the talaq process. And if that completes, the talaq will be over, and after the third pronouncement, talaq become irrevocable. The next form of talaq is talaq-e-biddat, or talaq-ul-biddat, or talaq-i-badai. This consists of 3 pronouncements made during a single tuhar, either in one sentence. Example, I divorce thee thrice. Or in separate sentences. Example, I divorce thee, I divorce thee, I divorce thee. Or I talaq you, I talaq you, I talaq you. These 3 separate sentences, it can be pronounced. Second, a single pronouncement made during a tuhar, clearly indicating an intention irrevocably to dissolve the marriage. Example, I divorce thee irrevocably. So this form of talaq, single pronunciation is enough. With the intention can be either singular or separate. Single intention means I divorce you thrice. Means thrice the word using with the intention that it is pronouncing 3 times. In separate sentences, I divorce you, I divorce you, I divorce you, in 3 separate sentences. Triple is either singly or separately necessary in these forms of divorce. Or another one is I divorce thee irrevocably. The word irrevocation is in the sentence. These category comes under talaq-e-biddat. So the talaq classified into 2, talaq-e-biddat, or instantaneous pronouncement of divorce in the form of triple talaq, and talaq-e-sunnat, having 2 forms, talaq hasan and talaq hasan. Talaq hasan consists of a single pronouncement of divorce made during a tuhar period, means period between menstruations, followed by abstinence from sexual intercourse for the period of iddah. Talaq hasan consists of 3 pronouncements made during successive tuhars, no intercourse taking place during any of the 3 tuhars. In talaq-biddat means triple talaq, only 1 pronouncement. After the pronouncement, revocation is not possible. In all other forms of divorce, that means talaq-sunnat, revocation is possible. After the third pronouncement, in talaq-sunnat, talaq hasan, the talaq become irrevocable. Talaq hasan, only 1 pronouncement. After the iddah over, the talaq become irrevocable. But before iddah completing, the talaq is revocable. These are the various forms of talaq. Next one we are going to discuss is requirements of a valid talaq. In Shamim Ara vs. State of UP, it was decided by the Supreme Court that requirements of a valid talaq, there shall be 2 ingredients. One is the talaq must be for a reasonable cause, and 2, that it must be preceded by attempts at reconciliation between the husband and the wife by 2 arbitrators, one chosen by the wife from her family and the other by the husband from his family. If their attempts fail, talaq can be effected. It implies the talaq must be pronounced for a reasonable cause only. For unreasonable cause, talaq cannot be pronounced. And another essentials of valid talaqs is reconciliation. If that attempts fails, talaq can be effected. In Kunju Muhammad case, unilateral pronouncement of talaq, the husband must attempt for reconciliation by 2 arbitrators in accordance with Ayat 35 Surah 4. Attempt for reconciliation is vital. Court further held that a divorced Muslim wife's right to claim maintenance under section 125 CRPC doesn't stand extinguished by the enactment of the Muslim Women Protection of Rights on Divorce Act. It implies reconciliation is vital. Talaq must be pronounced for a reasonable cause only. If reconciliation attempts fails, talaq can be effected. Even if talaq has taken effect, a Muslim woman's right to file for maintenance cannot be barred by this act. She can file a maintenance petition before a competent court under section 144 of the BNSS or other relevant provisions. Next question is whether there is instantaneous and irrevocable talaq in the present case. In this case, 3 pronouncements were made on 2/2022, 12/6/2022 and 22/6/2022, and also given 90 days for revocation. Although this practice is incorrect, it doesn't fall within the meaning of instantaneous talaq under this act, which is already discussed in detail by this honorable court. In detail, in this case, the court held that the petitioner herein pronounced talaq initially on 2/6/2022 and for the second time on 12/6/2022. So the second talaq was pronounced without waiting 1 period and also without any attempts for reconciliation between the spouses by two arbitrators, one chosen by the wife from her family and the other by the husband from his family. Thus, the second talaq pronounced without completing 1 period and without any attempt for reconciliation is void for the said reasons. The third talaq also void. That apart, since the third talaq also pronounced on 22/6/2022 without waiting for fresh period in between the second and third talaq, the talaq effected by the petitioner is void otherwise. Therefore, there is no legal talaq in between the petitioner and the first respondent, and they have been continuing as husband and wife in the eye of law, and there is no legal divorce. This means the court held that the three pronouncements made within a span of 1 month constituted an incorrect form of talaq. Furthermore, since no attempts at reconciliation were made, the pronouncement of talaq is invalid. For this reason, the said pronouncement by the husband against the wife is deemed invalid and their marriage still subsist. However, coming to the offense under section 3 read with section 4 of the Act 2019, even though the talaq is sunnat attempted by the petitioner is void for the reasons already discussed. The intent behind the 3 talaqs pronounced by the petitioner is after reserving the right to revoke the same within 90 days by the husband. In such a case, it could not be held that the talaq-e-biddat or similar form of talaq which is instantaneous and irrevocable was pronounced by the petitioner so as to penalize him under section 3 read with section 4 of the Act 2019. In view of the matter, this petition succeeds. In the result, this petition is allowed. All further proceedings on file of Judicial First Class Magistrate Court arising out of crime in police station against the petitioner herein stand quashed. In this case, although the pronouncement was wrongful, the husband was given 90 days time to revoke the talaq. Also, the court held that the husband's pronouncement of talaq was not in accordance with the specifications of the act and it was not an instantaneous talaq or talaq-e-biddat. The husband's intention was not a valid reason for the divorce under this act. Also, the court held that the husband's intention is not an instantaneous or irrevocable talaq. He has given 90 days period for revocation. As a result, the court quashed the proceedings pending before the magistrate court in crime number in Dash police station. I am discussing this case to help ordinary people, means common people, understand the law. I will be creating law related videos like this one. If you are interested, please like, share and subscribe to my channel for more contents.